Good afternoon, Council. Thank you for your patience. I'm going to go through and ask that each one of you speak to make sure that the judges can hear you, and then I will ask each one of the judges to speak to make sure that you can hear them, and then I will ask Judge Gregory if I can proceed to opening court. Mr. Teeny?
Good afternoon.
Mr. Crabtree?
Good afternoon, Your Honors.
Mr. Harwell?
Good afternoon, Your Honors.
Judge Gregory, could you say something, please?
Welcome, counsel.
Thank you. Judge Wynn?
Welcome.
Judge Thacker?
Good afternoon.
Thank you. Judge Gregory, may I proceed to opening court?
You may.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Mr. Teeny, you may proceed.
Well, good afternoon, Judge Gregory, and may it please the court. My name is Derek Teeny, and I represent the petitioners on this petition for review of North Carolina's Clean Water Act Section 401 certification for Mountain Valley Pipeline's Southgate Extension Project. We are here on petitioner's motion for stay pending review, which was filed after Mountain Valley accelerated its construction schedule in late January of this year. A stay is necessary to prevent MVP from completing all of the stream crossings authorized by this permit before the case is resolved on the merits. Petitioners request a stay because they can satisfy all four of the Nikin factors. On the merits, there are two flaws. First, this court has already held in Sierra Club versus West Virginia Department of Environmental Protection that an agency acts arbitrarily and capriciously when it predicts compliance without explaining why the same measures that failed before will work this time. North Carolina DEQ made exactly that error here. It's the same company, the same construction method, the same assurances, and the same lack of explanation. The second merits flaw is that DEQ compounded its error by failing to make compliance with certain measures it relied on express conditions of the certification. Instead, it insists that Mountain Valley Pipeline's entire application package was somehow incorporated by reference into the permit, including MVP's promises to contribute to a reduction of Duke Energy's carbon emissions and to generate millions in tax revenue, both of which would be absurd conditions in a Section 401 certification.
So thus far, there has been no construction in North Carolina, correct?
I believe that to be the case. It's my understanding.
Okay, well then how could there be a record of non-compliance in North Carolina?
You are correct, Your Honor, that the record of noncompliance is not in North Carolina. The record of noncompliance is in West Virginia and Virginia. But I would submit that my West Virginia driver's record would be of relevance to the North Carolina DMV if I were to apply for a license there. The same construction methods, the same construction measures, and in fact, the Piedmont region of North Carolina is very similar, if not identical, to the Piedmont region of Virginia, where many of these violations occurred. The last 55 miles of main line were in the Piedmont region of Virginia after it crossed through the Blue Ridge and then approached the state line there in Pittsylvania County. And so if you look at their record...
And why aren't the reasons given by North Carolina DEQ sufficient here?
In the record, North Carolina DEQ offered 5 reasons, well, 6 total reasons, 5 of which were procedural, 1 of which was substantive and was just a plain error. But all of those measures that they offered were implemented by Mountain Valley Pipeline during its mainline construction. And so in that way, those measures were similar to the repackaged measures that were found insufficient by this court in the West Virginia Department of Environmental Protection case. The idea is if you are committing to do the same things, but those things prevented the violations last time, you need to have an explanation of why things will be different this time. And that is utterly lacking from North Carolina's explanation of its issuance.
So you posit this as though this is the same project as what we addressed, I guess, earlier in the Sierra Club decision in West Virginia. And you say same parties, the same, that sort of thing, but there are a lot of differences. I mean, you're talking about different states, different water standards, different mechanisms, a different project. Not the least of which is when we, as I recall in the earlier case, it seems to me the big difference was it was the same case. And after it had gone through a lot of iterations, it came back and said, well, you've done this before. You've done this before. And therefore, maybe a question of credibility of whether or not you would do it was there. But this is a totally different situation. What's the relevance here in this case?
Respectfully, Your Honor, I don't think the differences are quite as profound as you might think.
Well, when I say it's a different state, that's a difference.
That absolutely is a
When I
difference.
say that the water standards are somewhat different, that's a difference.
Only minimally, and let me explain why.
And it's a different project. I mean, the earlier one was a massive project. I mean, as I recall, it's the beginning of things. So this is sort of morphed in something different, maybe some call it whatever, a spur or something else that's there. But isn't this, I mean, it seems like it's different to me. And even so, wasn't that considered?
It is not evident from the record that North Carolina presented that it considered the differences with North Carolina. The very differences that you've identified, I'd like to explain why they're not quite accurate, but North Carolina did not engage with those. You are correct, there is a state line, but the geographic line doesn't make a difference between the Piedmont region that Mountain Valley Pipeline mainline crossed and the Piedmont region in North Carolina. EPA recognizes them as the same ecotype, and that is why regionally and geomorphologically they are the same, even if they are different sovereigns. And the water quality standards that are issued are virtually identical. These are the narrative standards that prohibit sedimentation and turbidity. We aren't talking about a question of, well, North Carolina restricts PCBs to X number and Virginia restricts them to Y. This is the same narrative standard involving the same pollutants, sediment and turbidity, which were the problem on the main line. So yes, it is a separate project. It is shorter than the main line is. That is undeniable. But it is the same company implementing this. I'm sorry.
Did North Carolina address any of the issues that Judge Wynn just brought up in its rationale?
Not in its rationale. In its rationale, which exists in the hearing officer's report, which was one of the exhibits to our motion, the hearing officer addresses comments. And the hearing officer recognizes that there were comments about Mountain Valley Pipeline's compliance history and the vast magnitude of the violations that occurred during mainline construction. And all the hearing officer offered in response to that were assurances that Mountain Valley Pipeline was going to do 5 things on Southgate. It was going to have inspectors, which if you recall from the West Virginia case, was something that was present on mainline. They were going to have pre-construction meetings. Again, that was going to occur on mainline. The other 3 are I'm happy to dive into them if the point is all 5 of the procedural measures they offered can be found as requirements for mainline. And so to the extent he's offering an explanation, the explanation he offers doesn't explain.
And one of them was that MVP self-report non-compliance.
That is correct. And MVP was already required to do that under the West Virginia oil and gas permit, which provided that they had a duty to mitigate the impacts of their construction and that they report violations. And if you combine those 2, if they did have knowledge beforehand that a violation was going to occur, that would be subsumed by the duty to mitigate under the oil and gas permit.
Can you address your second argument since your time is
is waning, certainly.
Waning, yes.
Yeah, the second argument also follows on this court's holding in West Virginia Department of Environmental Quality, and this one doesn't turn on the differences in state or in construction. This is a matter of law, that Section 401 requires, as this court held in the North Carolina Department of Environmental Quality case versus FERC, and in West Virginia Department of Environmental Protection, 401 requires when a state concludes that some action is necessary to assure compliance with water quality standards, it has to be included as a condition of the 401 certificate. And in this case, there are...
Right, and why isn't condition 3 sufficient for that?
Condition 3, if I recall correctly, that's the one that requires them to obtain an approved plan.
Yeah, to secure an approved stormwater management plan.
And the reason is it does not require them to comply. Words have meaning, especially when it comes to the Section 401 certificate and its interplay with the Natural Gas Act. Remember that the Natural Gas Act preempts any state law or any state regulation of the pipeline that does not come from the Clean Air Act, the Coastal Zone Management Act, or the Clean Water Act. These stormwater provisions that North Carolina insisted could assure it that there would be compliance with water quality requirements are creatures of state law. They are not part of the Federal Clean Water Act program. And so thus they are preempted. So the enforcement provisions that North Carolina would ordinarily use to enforce a stormwater plan that's obtained are preempted by the Natural Gas Act, and that's 15 U.S.C. 717B, subparagraph D. But there were two other conditions that also should have been included. One, Mountain Valley, the hearing officer offered that North Carolina could be assured of compliance with water quality standards because Mountain Valley would use methods applicable to areas with high quality waters, despite the fact that there weren't such waters in Mountain Valley's pathline.
What about condition 2, this incorporation of the plans and specification?
Certainly, Your Honor. Plans and the incorporation by reference is a litigation position that simply can't bear the weight that they would put on it. First of all, plans and specifications is a term of art, as the Supreme Court has recognized since 1918 in the Spearin case, that applies to engineering designs. What that condition does is say it approves the project, the what and the where. What it doesn't approve is the how. The plans and specifications don't include the environmental compliance.
Should condition 2 be interpreted rather broadly here, or do you see a very narrow interpretation of it?
I think it has to be interpreted narrowly for two reasons. First of all, if it were interpreted as broadly as the state and MVP offer, it would it would render redundant other conditions of the permit that specifically...
But let me understand it. I don't want to cut you off on that. That seems like to me, we have to remember where we are. We're at a preliminary stage. There's a merits coming along. Do you really want to argue that against this being a broad interpretation, if they're willing to agree that there's a broad interpretation? I mean, wouldn't you prefer that MVP be bound by more conditions? I mean,
Your Honor,
you're here making an argument, and I'm wondering if when you show back up, you're going to jump on the other side of this possibly and says this should be broadly interpreted, so that they have these conditions. But here you're saying, no, it does not have it. I'm wondering, how does that fit in your argument?
Certainly. I may be accused of a lot of things, but I hope I'm never accused of being inconsistent on my positions. I will not come back and try to argue that should be interpreted broadly. And I know that, the art of war tells us we should not interrupt our opponents when they're in the process of making a mistake, which I think Mountain Valley Pipeline is.
But it seems to me as though they're willing to admit that it can be interpreted broadly.
Well, maybe this is a case where we lose the battle but win the war. I don't know, because I
don't know what battle you're winning and losing by saying, this provision does not comply with it. If in fact they're willing to say, yeah, those extra things that you say, we are bound to do those things.
Your Honor, the application is not limited to those things. There are dozens of affirmative commitments and use of the word will to describe what the project would do. And I don't know what the limiting principle would be to determine which of those affirmative statements that Mountain Valley made in its application are enforceable under the Clean Water Act and which are not. For example, they say that their project will pay approximately $1.5 million in ad valorem tax revenues annually on average. Is that enforceable through the Clean Water Act? It certainly shouldn't be. That shows the
let me
absurdity
come
of
at
the
a different
resulting-
angle on this, and that is because we're dealing again with preliminary stage. You didn't make this argument in your initial motion. You did so in a reply brief, and normally that's not something that we allow because you don't get a chance to respond on the other side of it. And, given that procedure posture of it, I mean, why should we even consider this at all?
We raised it in reply because it was only raised in response. We had no idea that they were going to offer this broad interpretation of the term plans and specifications to incorporate. I see that I'm out of time. May I conclude my response?
You may.
Thank you. We offered our affirmative case in our motion. They said these things were necessary. They're not conditions of the permit. They looked at their permit, realized they weren't conditions, constructed an argument that everything in the application was incorporated by reference, and we replied to that in our brief. I think that this argument is appropriately before the court, respectfully. With that, we respectfully request that the court grant the motion to stay.
Thank you, Mr. Tini. Mr. Crabtree?
Good afternoon, Your Honors. May it please the court. Special Deputy Attorney General Taylor Crabtree from the North Carolina Department of Justice on behalf of the respondents, the North Carolina Department of Environmental Quality, Secretary Reed Wilson, and Director Richard E. Rogers. Respondents oppose the motion to stay. The North Carolina Department of Environmental Quality is no rubber stamp for pipeline approvals. I stood before this very same court 5 years ago defending a denial of 401 certification request from this very same company.
It may not be, but you have to be mindful of the next case coming up. And if you look what Virginia did and what North Carolina did, it looks rather cursory to me compared to the kind of responsiveness that was given by the agency there. And I'm sure you're familiar with it because, it's, like I said, it's the next case coming up. And I'm not saying it's not sufficient. I'm just saying if there's a case where it looks like it's a little cursory, there were a lot of things that were sort of left out here that quite likely should have been put in, I think.
Yes, Your Honor, I can speak to that. I think Virginia is in a very different posture, as Your Honor identified with your discussion with my friend on the other side earlier in the colloquy. Virginia has had MVP. It had its own record of noncompliance, with Virginia's program, with Virginia's conditions, with Virginia's 401 certification. And I don't think those are necessarily distinguishing facts that need to be in the hearing officer's report, but I do think it speaks to the degree of explanation that should be expected and should be required when an agency
But
has...
North Carolina was aware of the history of noncompliance of this company and this pipeline, correct?
Yes, Your Honor, we were aware as the hearing officer...
So where is the explanation for why things will be different this time, just because it's in North Carolina?
I think North Carolina is entitled to rely on its own experience in implementing the 401 program and using its 401 program to protect its water quality standards. And this is not the first...
So you're saying, so is the reason, one of the 5 reasons that North Carolina says that will ensure compliance this time is North Carolina's strong enforcement program. Is that what you're speaking to now?
That's one aspect of it, certainly, Your Honor. There's also, I think there are...
And all the others seem to me, or most of the others seem to me to be basically because the company says so, because they pinky promise they won't do it again. That's what it feels like.
I don't Respectfully, Your Honor, I don't think that's fair. I think if you look at this case and compare it to the certification that this court considered in West Virginia, there are at least three very notable differences between that case and this one. And I
Right.
think first among those, and I think probably most importantly, is North Carolina relied on two things principally to address, to say why this pipeline won't cause violations of water quality standards. And that's its erosion and sediment control program, both during construction and after. And unlike in West Virginia, where this court held that those conditions, that the oil and gas permit that the HC was relying on in that case was not a condition of the 401 and was therefore potentially preempted, we have an express condition, Condition 10, that incorporates the entirety of the Sediment Act in North Carolina, that is a robust regulatory structure to address precisely the kinds of construction stormwater impacts that we're talking about here. That's not present in West Virginia, and it's a big distinction here.
And where is that explanation present in the rationale provided by North Carolina?
Yes, Your Honor. It's on page 5 and 6, starting on page 5 and continuing into page 6 of the hearing officer's report, which is Exhibit 2 to our response. So it's in the context of, remember that this question about compliance history is not itself a separate requirement of any statute or regulation. It's about whether the project can be expected to comply with water quality standards.
Mm-hmm.
And so
And
everything
you said there were three important differences, and that was your first one. I'm interested in the other two as well.
Yes, Your Honor. So we have the first one, which I think is the most important, which is Condition 10, which is the incorporation of these other regulatory regimes. We have something that's already been addressed at some length today, which is the fact that MVP committed to over-engineering the project to comply with North Carolina's rules and regulations.
Okay, so that's where I said earlier that because the company says so.
No, Your Honor, not just because the company says so, because the company said so, and Condition 2 requires them to live up to that commitment. And respectfully, that is not a litigation position. My client we include Condition 2, incorporating by reference the plans and specifications of projects in the 401 program in every 401 certification that we issue, and we rely on that condition all the time. Our inspectors and our staff rely on that condition to avoid having to regurgitate applications that can run into the hundreds of pages to make sure applicants do what they say they are going to do. It makes perfect sense. This is what the applicant is asking us to certify, which is, hey, if we do what we say we're going to do, what addition will that violate water quality standards? And what we do in a 401 certification is we say, yes, but do these things too. So we have this condition to require them to comply with what they say they're going to do. And the superfluity canon that my friends point to in their brief is it just can't bear the weight that they place on it. I think their interpretation of the condition would render Condition 2 superfluous. That's just not sufficient. And as Judge Wynn pointed out, and Judge Gregory pointed out, we now have, if you were worried about it at all, we have now the regulated party, to their detriment, coming to this court in writing, in their briefs before this court, and I anticipated argument as well, and saying, we are bound by what we said. And why shouldn't we take them at their word? This is not
because of the history of noncompliance.
Well, I don't think that changes whether they're bound. You know, you don't have to.
And I'm sorry, I think I interrupted Judge Wynn and you as well, Mr. Crabtree.
No, I'm
Judge
sorry.
Wynn,
Yeah, well, I see where you're going with this in terms of, in particular with the incorporation. But given the given the lengthiness of how long this has been going on, and it may have gone on maybe 100 pages or so, it seems to me it would have been cleaner just to put those conditions in the certification itself, particularly in a case like this, rather than seeking to incorporate them. But if I understand you correctly, this is more or less like a concession, or at least an admission that whatever it is the other side is asking in terms of whether you are bound, you are now establishing, I would say, at least to the point of there being a good case for estoppel, yourself as admitting that these are conditions you're bound and would bind the MVP by. Is that correct?
Yes, yes, Your Honor. Certainly, I think that there is a strong argument for estoppel here. I don't even think you need to get there, though. I think,
But we don't need a strong argument for estoppel if I'm getting a concession straight up from you right now. That's exactly what it says.
Yes, Your Honor. Sure.
Maybe we call it estoppel, but it seems to be pretty strong to me. If you get a party on the other side and one is saying that it doesn't mean something, you said, yes, it does. And you're telling the court now, and this is the same case, although albeit in a different procedural place. And that's why I asked your colleague on the other side, is he going to come back to this court arguing something different when it comes up? Because it looks like to me it'll be in a different posture, and that's what he's going to want. He's going to want a broad interpretation of it at that point in time, I would think. But just to be clear on that point, because I think that's a very a good situation to be in now, particularly given since, you know, he only raised this in a reply. So, I mean, the court very well could just say, okay, we won't deal with it until we get to the merits on it. But there's a reason to deal with it now. If this is very clear at this stage, we don't need to come back and relitigate or get into questions of, you know, what does it mean if that is the posture that's being represented and understood here today.
Yes, Your Honor. I think that's a great point. Let's just play that hypothetical out. If we did, you know, to your Judge Thacker, your point, if MVP did, and I don't have any reason to believe that they won't, but if they did not live up to these commitments down the road, and my office sought to enforce those as we would, they would be hard pressed to argue now that they're not bound by these commitments.
Well, that question will go to the MVP representative next.
Yes, Your Honor.
We got the one side in terms of you and whether you're going to make sure they're bound by it, but they need to make sure it's understood what you're saying. They understand it to be the case too. So, we're not going to leave that stone unturned. And I don't know what I think it would be. I think it'd be more than disrespectful. I think it would be something else to make that representation today and then come back and say something totally different in a marriage type situation.
Mr.
Yes,
Crabtree, Mr. Crabtree, you describe the certification as being a strong enforcement program. Does that mean that you're going to take efforts to punish them after if they violate it, or it means that you're going to do something special to make sure they don't violate it at all? Which is it that makes it a strong enforcement?
I think it's both, Your Honor, both and. So we have on the prospective side, the Sediment Act that I've referenced. It requires, and I see my time has expired. If I can just briefly conclude, I'm happy to, or I can stop it.
Oh, you can. Go
Thank you, Your Honor. So on the prospective side, we have a robust program through the Sediment Act that requires the company to submit very detailed plans of just how they are going to construct the project in a way that protects water quality standards. If you look at the engineering specifications, they're very, very detailed. So that's on the preventative side. And then on the enforcement side, we do take action when these aren't complied with. And so it's a both and approach. And Your Honor, I think based on the arguments made today, I think we would contend that the stay motion should be denied, primarily because we don't see that they've made their showing of a likelihood of success on the merits. Thank you, Your Honors.
All right, thank you. Mr. Marwell?
Thank you, Your Honor. Good afternoon. Jeremy Marwell for the respondent interveners, including Mountain Valley Pipeline, and may it please the court. If possible, I'd like to start with the question of what the certification requires, the enforceable conditions, since that was teed up. 2 points on that, and then I'd like to speak to the adequacy of the agency's explanation with regard to the history of noncompliance. And if I get to it, one brief sentence on the other state factors at the very end, the 3 other factors. We'll see where we get.
Start where we left off and go right to what you just heard your colleague represent and get that off of the table one way or the other. I'm not backing you in to admit one thing or another, but I want to know the position of MVP insofar as what's being represented by the state agency, particularly regarding condition 2. And how do you see that broadly in the manner they say, and also whether you are bound by those conditions that may not be so explicit in the certification, but at least the state seems to think they are. And I want to make sure that the two of you are agreeing on that and where we are.
We are in vigorous agreement with the state that we are obliged, we are bound to comply with those conditions. And I'm trying to be as clear as I can. We think that flows from the plain language of the conditions, but also if you have any concern, condition 2, which incorporates the other conditions by reference. On condition 3, I mean, the petitioner's lead argument is about the stormwater concern. The requirement to secure an approved stormwater plan, I think, is naturally understood to require us to comply with that plan. I mean, if my child said, I want to have my friends over for a party on Saturday, and I said, okay, but you got to tell me your plan and get my approval before you do any of that, I think most natural English speakers would understand that he has to comply with the plan. And the notion of the parties' understandings of a permit being relevant to you goes to this question of interpreting a permit like a contract. This is the Ohio Valley case that is cited in the briefs. You do have a case.
But what's the rationale for saying that just because someone says they're going to comply with the plan, they actually will, particularly given the history of noncompliance? That's the concern, at least for me.
I understand, Your Honor. One thing that may be helpful is that immediately after that condition, the agency cited to a portion of its administrative code which speaks to enforcement. And the whole premise, I think, of what we're discussing is that the certification is enforceable, right? That's why it exists, to make sure that enforcement can occur. In this Virginia Electric and Power case, 903 F3rd at 403, that's a decision of this court. The court cited the restatement and said, in the context of a clean water permit, what you're trying to give effect to is the shared intent of the parties, and here the parties are us and the state. So I think the concept of why our view matters is consistent with your precedent. I also would like to step back, and when you're thinking about the principles in writing an opinion about how to interpret this statute, on the one hand, the petitioners are saying every important material element to the state needs an enforceable condition. Okay, fine. On the other hand, they're saying you should apply an anti-redundancy canon to narrowly construe provisions in the certification that might otherwise avoid the existence of a gap. And I don't think that's a sensible way to interpret a document that has a intention of providing protection for water quality. If you are nervous about the incorporation by reference, and I don't know that you should be, I think it has a basis in the text. Also remember that condition 10, see that we've lost Mr. Teeny.
Yeah.
Should I stop?
I had to plug in my laptop. I apologize.
That's fine. I stopped as soon as I saw you, so you didn't miss anything. May I continue?
Yes, you may.
So condition 10, which explicitly incorporates the Sediment Act, which is the statute that Mr. Crabtree was speaking to earlier, requires us to obtain an approved erosion and sediment control plan. This came up in the petitioner's reply brief. One thing you saw in the reply brief is that the high quality water elements are part of that plan. The other thing that you didn't see in the reply brief is that our coordination with the other pipeline in the area is also part of that approved plan. That's at item 19, page 8 of our erosion and sediment control plan, which is linked in the petitioner's reply. So that is an enforceable, express condition that requires us to do those things as an additional sort of belt and suspenders approach if you have concern about the incorporation through condition 2. If I might speak to the adequacy of the agency's explanation, unless there are other questions on the enforceable condition. Judge Wynn, I hope I have satisfied your questions about the Mountain Valley's position on those issues.
You seem to have been very vigorous in the way you give it. And, you know, we hear back, when we come back, we get all kind of nuances and interpretations from lawyers. I did the best I could, and I think you did too.
I understand.
At least it seems to me as though you were saying you're clearly bound by it. This way, is as close to concessions I think could be made, unless somebody else sees it differently.
Thank you, Your Honor. As to the record of enforcement issues on the main line and the adequacy of the agency's explanation, just a few points. First, we take the issues that arose early in the main line very seriously. We have worked hard to improve the practices and avoid those issues. I hope we will explore that more in the next case that comes, where there's a more fulsome record that compares Virginia's history to Virginia's certification. With regard to the question of why it is going to be different this time, I'd like to answer that, but also urge you, I don't read this court's decision in West Virginia as saying that is the only way for a state to give a reasoned explanation when faced with a record of noncompliance. A state could also, I think, reasonably differentiate between the projects and say this is a different project. I mean, remember, in North Carolina, this is 5 miles of pipeline. That is much, much smaller in objective and relative terms than the main line. I would urge the court to look not only to the section of the hearing officer's report that directly acknowledged and addressed the concern raised by petitioners about compliance, but also the section that Mr. Crabtree referred to, which is a few pages earlier in the decision document, that talked about why the state had confidence that the project would not violate water quality standards. That is, I don't think you can, that is all part of the same discussion. Obviously, enforcement.
Well, did the comments indicate that that was part of the same discussion? Did the commentary in response to the noncompliance issue say, oh yeah, and also you should look back at the pages prior? We're relying on that too.
So the way that the document is structured, it identifies the comments in bullet points and then responds to the comments. And so in that section on page 5, among the other things that the hearing officer was referring to and responding to was a concern that the proposed activity will not comply with state water quality standards and various specific things that they will cause turbidity, sediment, erosion, storm events, excessive sedimentation. I'm sorry, I see my time is up.
So then the answer to my question about whether the response on the history of noncompliance referred back to that prior page 5, the answer is no. You have to look at page 5, and then you're saying that somewhere in there it talks about the history of noncompliance, but the specific comments in response to the concern about the history of noncompliance do not refer back to page 5. And we know that North Carolina knows how to incorporate things by reference, and they didn't do that there, correct?
Yes, may I sorry, I
Yes,
see
you
that
may.
I'm over my time, but may I? Yes.
Yes.
I think that's correct, Judge Thacker. I should say I don't view the Chenery doctrine that the court needs to look to contemporaneous explanations given by the agency. In other words, not litigation positions, but positions at the agency, to just have such a sort of stringent edge to it that you would ignore a section of the agency's contemporaneous decision document that seems on point. You know, the question is about what are we going to do and is it going to be effective?
No, I understand your argument. I just wanted to get a specific answer to my question, and then you could have made your argument. And I understand your argument completely.
I understand. I'm sorry if I wasn't directly enough responsive. May I make one final point, Your Honor?
Yes, you may.
Just on the other 3 stay factors, which haven't gotten a lot of airtime, this project is being developed in response to demonstrated need by 2 utilities in North Carolina that are responding to urgent growth in energy demand. We are not building this on spec. We are building it to a timeline that the utilities need, and there are real consequences to the public, to the energy consuming public, of delaying a project coming online. Among other things, we are trying to provide gas to help Duke to retire coal-fired power plants and replace it with cleaner burning gas-fired power plants. So I would urge you, as you think about the factors, to weigh that public interest, harm to non-moving parties as part of the calculus.
It would be real difficult to get into that realm of it. I think sticking with the first factor is a good thing. I mean, the environmental concern, whether it's contemporary or future, is in every instance, and when we approach it from that economic and that benefit approach, it gets into a very fuzzy area. It might sound good today, but for many, and you're talking about the public's interest, it reaches deeply into our environment and what it means. So there's a real argument that's being made here. It's not just being made for sake of just to irritate anyone. And you have a good point, but I think it has to be balanced with that.
I understand. Judge Gregory, may I respond to Judge Wynn's question?
Well, one thing I
I'm not
think
sure
that
it
maybe,
requires
maybe,
a response.
Mr. Marwell, you open up a can of worms, and maybe you're one comment too much, because while you said we look to the future, and all of us do in terms of the benefit of us, then also the corollary that we also look to the past in terms of what we have to do perhaps to prevent the same thing from happening, and maybe in Virginia and West Virginia too. So when you do that, when you pick up that coin, you got to realize another side of it too, and that is the question. There's an Ohio case that says, just saying I will sin no more, and I realize you sinned before, that's all you do, is not enough. So that's the real question: is has North Carolina done enough to make sure, to assure that this is truly a new and strong enforcement question? And I don't think anybody disputes the efficacies of energy and public good, but that's why these things are protected environment that we'll have to live with for hopefully eons and eons and times as earthlings, not separated just by states or countries or continents. All right, I think with that, we'll let Mr. Tini have the last word.
Thank you, Your Honor.
Thank you, Judge Gregory. I'd like to visit the question of contract interpretation, because we completely agree with North Carolina and with MVP that the permit should be interpreted like a contract. That's what the Ohio Valley Environmental Coalition versus FOLA case holds. And both Virginia and North Carolina apply the four corners rule to contract interpretation. And what MVP and North Carolina are inviting you to do is to consider evidence of their intent beyond what was put on the pages of the paper. And that is a dangerous precedent to set, given that this is a unique circumstance where the question of what the contract means is coming up outside of the enforcement context. Right?
I think that's a interesting way to approach this, but I don't want to get confused. This is not a contract case. I mean, our review is not a de novo case. We're not looking in terms of interpreting provisions here. This is a case that's dealing with arbitrary and capriciousness on the part of an agency that factually, we're in the factual realm of giving deference to. And so I think that's a different type of case. And I got your analogy to the contract thing, sounded interesting, but I don't want to get confused on it. It may be like a contract, but our review is of the agency's decision. And the issue is whether it was arbitrary and capricious in making a decision in which it itself has some measure of expertise on it. It's not a Chevron type case at all. And from my perspective, it's one in which you do that's been preserved by the Supreme Court, that we review these cases from the agency because rightfully it does have a expertise that we don't have. I mean, I can talk this stuff with you, but at the end of the day, they got the expertise on it, and our job is really to determine where it would be arbitrary and capricious, and that's where it's helpful to us in your arguments, and you did a pretty good job sticking in the briefs to that. But maybe that's just the way I see it. But
respectfully, Your Honor, I'd ask you to consider this: that the standard is not just arbitrary and capricious, but it's also otherwise in accordance with law. And I think a close look at the Ovec versus FOLA coal case stands for the proposition that the interpretation of a permit is guided by contract law and not by deference to an agency. And there's no contrary law in this circuit that holds that permittees or agencies should receive deference on how they interpret a permit. Otherwise, it would create chaos on understanding what's enforceable in a citizen suit and what is not. And so for that reason, that's why the court has held that it's interpreted like a contract. That's consistent with the way the Ninth Circuit has interpreted it. I think if you were to analogize this, you said you don't have expertise. I beg to differ. This is a strict question of law in this case, not a question of any expertise of what level of sediment will cause a water quality standard violation. This is a question of what words mean on paper. And so this does feel a lot like the Loper-Bright situation, or a lot like is it Kaiser versus Wilkie that put the constraints on our deference, the interpretation of a regulation. The knee-jerk reaction to defer to an agency when the question is really one of law would set a precedent that is contrary to Ovek versus Fola, quite frankly.
Well, you need to help me on that. I thought this was primarily a factual question. I mean, question of whether in fact they complied with conditions, they're bound by it. The law seems to be pretty settled on it. We've already established that, at least in prior cases here, what the law is on it. So I don't think we're in a statutory interpretation type case, which would be a Chevron or, as you say, Loper-Bright type situation that we would be dealing with. And I don't want to confuse this thing because maybe you're kind of saying the same thing in a different way, but I want to make sure we stick to what the standard of our review is of this case.
Absolutely, Your Honor. And this is an issue that's near and dear to my heart, and I have thought a lot about. So I'm not on the fly here, I assure you. While it may not be a question of statutory interpretation, it is a question of contract law. And interpretations of contracts are reviewed de novo. And so therefore, the part of agency review that allows the court to examine questions of law de novo applies here. Yes, it's not the interpretation of a statute. Perhaps it's more analogous to the development of a regulation, which would put it.
What is the legal question? What is the legal question? Are you saying that the question is whether the conditions were incorporated by reference? Is that your legal question?
I see that I'm out of time. May I respond to the question?
You may.
Please.
Thank you. The legal question is, what do the words on that paper mean? What does it mean to incorporate plans and specifications? Does it mean to incorporate the length and the width and the materials of the pipeline? Or does it mean to include every word that is in the application as a binding condition? That is a question of law, not one of fact, and there's no reason to defer to the agency, and especially not to the applicant. With that, we respectfully request that the court grant this motion for stay.
Thank you, Ms. Teenan. Thank you, counsel. Mr. Crabtree, Mr. Marwell, thank you for your arguments. We can't come down and shake your hands as we normally do in the Fourth Circuit, but know that this is a very hearty virtual high five. Thank you. We proceed to our next case. All right, Mrs. Teeney, you're up again first.
Thank you, Judge Gregory, and may it please the court. I'm here on behalf of the petitioners in the Virginia 401 certification challenge, which presents very similar legal questions to those in the North Carolina case, but with some nuance. So I'd like to kind of dive into that, and maybe even picking up on the last question that we got to, which was the question of interpretation. Because Virginia, like North Carolina, is saying, no, it doesn't matter that we didn't specifically require compliance with erosion and sediment control, even though we included that as a condition in the last 401 certification we issued, because we incorporated it by reference by binding them to construct the project as described.
And North Carolina just did something, at least that case, that kind of took it a step further. They basically admitted that's what they did. Everything you say it should be done, they said, yes, we agree. That's what we're bound to be bound by. It sounds like to me they satisfied just what you want. I mean, they did it in a court of law right here in front of us and said it as plainly as it could be. I don't know how much plainer you could get to be it other than, you know, if you can't trust the fact that they say it to us and then we'll come back to this court again on the merits of it, it seems to be pretty straightforward on that point.
If the issue here is unique in that we are considering representations in court about what a contract means before it's trying to be enforced. And so there is this strange two bites at the apple, and there has to be a choice about, which case to win or lose in some ways,
And in the abstract where you have that, I got it. But when you have parties on the other side that come into court and says everything that you say you think that contract should have done, they said, yes, it does, and we are bound by it. I don't get it. It sounds like to me you have what you want on that.
I think the issue is that Congress has preempted these laws. And I don't know that they can have an agreement to undo that which Congress has preempted in the Natural Gas Act. And the reason, quite frankly, that my clients are so concerned about this is that this company, Mountain Valley Pipeline, has twice sought relief in court from efforts to enforce state or local laws under the preemption doctrine. And in one of them, it involved the Commonwealth of Virginia's efforts to enforce a 401 certification. The case that is commonly referred to as the Paler case that involves...
Do you see the problem you could run into in the future if this case comes up and they don't comply with those conditions? They get up and make your same argument, say, yeah, we said it, but Congress has preempted us from doing it. How are you going to handle that? You're going to come back and say, well, Your Honor, that was what I said, even though the court feels differently?
Well, yeah, I wouldn't be judicially estopped, I don't think, under the, you have to prevail. If I prevail...
I'm not interested in estoppel. I'm interested in how you represent something in this court right now. Well, estoppel to the extent, but I mean, it would not be a kind day for that to happen in this case, particularly if you come back to this same panel, but even if you come to this court, I can't imagine it would be a kind day for parties, the same parties to come back in and take diametrically opposed positions that have been very clearly stated to us and represented in this case.
I think what's happening here is an amendment to the certification by testimony in open court or representation by the parties. The enforcement action would occur either by the Army Corps of Engineers, by the state that's affected, or by a citizen suit brought by parties, not just by my clients, but perhaps others. Take, for example, Pittsylvania County. Let's say Pittsylvania County didn't feel that it was getting its fair share of taxes. Mountain Valley committed to paying it a certain amount. Pennsylvania County sues them under the citizen suit provision, trying to recover that amount of money. They weren't a party to this case, so judicial estoppel by its own terms doesn't apply. The case is going to occur in a district court, and the preemption defense is going to be very tempting, wouldn't it be? That Congress, I mean, it's remarkable to suggest that they can agree in open court to supersede that which Congress prescribed in the Natural Gas Act.
Let me ask you one other question, just for clarification.
Sure.
This particular instance, there was FERC approval. And as I understand, there's something being filed in the D.C. Circuit, too. Was it in this case? Because Congress sort of gave that FERC approval business to them. This is a different kind of case. So are you seeking this same kind of remedy in the D.C. Circuit, too?
No, Your Honor. What is being sought in the D.C. Circuit is judicial review of the FERC certificate itself, based on the standards.
It's Virginia case. You got an approval here. I don't think you got an approval yet in North Carolina, do you?
Oh, we do, Your Honor. That was actually issued first in November of 2025.
So you have two FERC approvals, not just one. I don't know why I thought there was only one.
No, I'm sorry, Your Honor. And I don't mean to confuse. There is one FERC approval for the length of the pipeline across Virginia and North Carolina.
I got that, but I'm talking about for what we are talking about now. This particular project, I don't think that length FERC approval is going to work just for these spurs or whatever they call it. So I'm asking about this. What has been given FERC approval? And I think only the Virginia one has. Is that correct or not?
I don't believe that to be correct, Your Honor.
Okay,
In
okay.
December of 2025, FERC approved Mountain Valley's application to amend its Southgate project, basically to create this 31-mile pipeline. And FERC granted that amendment and approved it from its origin near Chatham to its conclusion in Rockingham County.
All
That
right.
is approved
Okay.
by FERC.
So separate
I
fund.
need to shift gears here because how is your argument not waived? Respondents argue that you failed to raise these concerns regarding the permit conditions in the notice and comment period, and so it's waived. What's your response to that? Where can I find that you raised these concerns before?
I believe that we submitted the document. They were raised in written comments submitted at a public hearing that was required by statute on January 6th. What's important to understand is that Virginia has 2 comment periods for controversial permits. The first comment period is only on the draft permit. We commented on what was on the paper in front of us. We did not understand at that time the reasoning that Virginia was going to levy.
Okay, so you're saying that in the first comment period, you did not actually specifically raise these issues, so they would be right about that. If that's all there was, that would be waiver. But you're saying that because you later brought it up in the second comment period, that that's sufficient for you not to have waived the argument. Is that it?
Yes, it is. The Virginia statute requires the department to publish responses to public comments and then to hold a public hearing to provide an opportunity for individuals who previously commented, either at a public hearing or in writing during the applicable comment period, to respond to the department's public comment summary and response. And that's exactly what we did on January 6th, and that should be an exhibit to our reply. We responded to their responses to comments where they said,
It is an exhibit. Why is that not too late?
Because the statute expressly allows individuals such as the petitioners to comment at that hearing in writing or in orally, and that hearing was held on January 6th. The permit was not issued until later. The department had the opportunity to respond to those comments. In fact, it acknowledged that the comments had been made in one of the documents accompanying the final issuance of the permit, yet it did not correct what would appear to petitioners to be plain error. So I guess the short answer is January 6th was a timely comment under Virginia statutes. And what Virginia and Mountain Valley Pipeline have picked up on is the final sentence of that statute conceivably says, no new information shall be accepted at that time. But this is not new information. Rather, this is a response to the department's public comment summary and response, which is the first time they disclosed their reasoning, which included these conditions, and therefore, that's why our comments are not new information. So the argument regarding the conditions is preserved. With my remaining time on the merits, I'd like to pivot, if there aren't any other questions about the conditions, to the other error that Virginia has committed. Virginia commits the same kind of blatant contradiction that West Virginia had predicted. In one breath, DEQ says in those documents that were released before the controversial permit hearing that it believes that water quality standards and water quality requirements will be complied with because Mountain Valley will comply with the erosion and sediment control plan. And then in the next breath, Virginia has to discount the hundreds of violations of the erosion and sediment control plan by saying that they don't think that they were significant or mattered in the ultimate course of things.
But that was based on, they considered 11,000 inspection reports and 9 different independent analyses of the mainline data. That was based on all of that. So how is that not a rational explanation?
because Virginia's own inspections and own civil penalty assessments are the source of how we know that Virginia was enforcing that erosion and sediment control plan through a $2.15 million civil penalty assessed through a consent decree during, if you think of it as phase one of Mountain Valley mainline construction. And then after the fact, after the Fiscal Responsibility Act was passed and Mountain Valley is completing its pipeline, additional violations were committed that Virginia DEQ fined them, I believe, close to $100,000. And that too is in the record. And so it's contradictory for Virginia to say, in one hand, we're sure they're going to comply because they're going to have to comply with the erosion and sediment control law, and then to say all of those violations of the sediment and control law that we prosecuted don't matter. It's just simply irrational. And that's the same reasoning that failed the
So
test.
you just don't agree with their conclusion based on their consideration of the 11,000 inspection reports and 9 different independent analyses. That's what it sounds like. You just don't agree. But they did have some rational, at least seems to me like they had some rational basis in this case, in the Virginia case.
The trouble is with their express statements. Where they said they were relying on erosion and sediment control, and yet they found violations. Yes, there were 11,000 inspections, but hundreds of them found violations that DEQ prosecuted and assessed penalties for. And maybe they didn't find a violation all 11,000 times, thank goodness, but they did find them a significant number of times. And the standard under Section 401 is not a...
But what they found was that there had not been any, quote, catastrophic aquatic impacts from the main line, and that the main line construction was, quote, protective of water quality. You just don't believe that?
I don't think that's the correct standard. Catastrophic is not the standard. It's
What
compliance.
about protective of water quality? Is that the standard?
It's protection. The statute provide, or the current regulations provide that they must comply with water quality requirements, which include state laws regarding water quality. The erosion and sediment control law is one of those water quality requirements. So when Virginia says we don't have any evidence of violations of water quality or impact, what they're ignoring is that their fact sheet says what the regulation requires, which is that they have to predict compliance with water quality requirements, which includes that erosion and sediment control permit that Mountain Valley Pipeline violated in Virginia hundreds of times. And so it's not that we just simply disagree with the conclusion, it's that the conclusion applies the wrong standard and on its face is contradictory to itself. And the regulations that I'm speaking of here are 40 CFR section 121.3, which is what required Virginia to evaluate compliance with water quality requirements, not just water quality standards. And then 40 CFR 121.1J defines water quality requirements to include any other water quality related requirement of state or tribal law, which would include the erosion and sediment control permits that Virginia found so many violations of. I see that I'm running out of time, so unless there are further questions, which I'd be happy to address, we'd respectfully request that the court grant the stay motion. Thank you.
Thank you, Mr. Tini. Ms. Kuhlbach, I think.
Kolbach, Your Honor.
Yes.
Thank you. May it please the court, Assistant Attorney General Catherine Kolbach, on behalf of the Virginia Department of Environmental Quality and the other Commonwealth respondents. Petitioners failed to meet their burden of showing that the circumstances justify a stay. Most notably, they failed to make a strong showing that they are likely to succeed on the merits. And if I have the time, there are 3 points I would want to go over on the merits prong. Number one is that MVP's permit includes erosion and stormwater management requirements, although this issue was waived as the petitioners failed to timely raise the issue before the agency. The second matter would be that DEQ gave a reasoned explanation as to why mainline violations do not violate the certification. And third, the one alleged error in the geosyntech report does not affect DEQ's reasoned explanation that Southgate will not violate water quality standards. And of course, this court reviews 401 certifications with deference to the issuing state agency. So as we review these issues, the questions to consider are whether the agency considered the relevant factors and whether a clear error of judgment was made. On the first argument,
So opposing counsel says that it was not waiver because their January 6th comment was timely because it was provided for in the statute, those comments, and that the Virginia just didn't respond to it.
yes, 9 VAC 25-210-172 makes clear that at the end of the public comment period, which includes that first hearing that was held, no new information will be accepted. Opposing counsel concedes
Right,
that.
and he predicted that you would say that you would say, you know, that's no new information, which is why opposing counsel explained, at least in his view, why this is not new information. Why is it not new? Why is it new information?
It's new information because petitioners had access to the draft permit, which is substantively the same as the permit that was ended up being issued. So they knew the conditions that DEQ included to protect water quality. If they thought a condition was missing, if they thought stormwater and erosion needed to be in there expressly, they had ample time to make that argument. They did not. Instead, during the public comment period, they made an argument that the standards and specifications did not have enough detail to protect water quality. By making that argument, they are conceding that DEQ can enforce the standards and specifications against MVP. Then, after public comment was done, after that first hearing, at a time when the agency by law cannot accept new information, now they raise the argument that the agency is preempted
Well,
from...
what's the point of the second comment period then? Why even allow additional commentary? Or was that just not allowed at all? Their January 6th comment?
That second hearing is required under that same regulation, and this
But
goes
pointless? I mean, you can't raise anything in the second hearing? I guess not new information.
Exactly. It allows commenters who commented previously to respond to DEQ's comments. This comment by petitioners goes beyond a response. It raises a whole new argument of preemption that they failed to make and could have made as they had access to the draft permit during the actual public comment period. DEQ was not required to consider that information as it was made outside the public comment period time. Had they made it during the public comment, then this same regulation requires the agency to consider that information. But however, while I do believe that they waived, that point is moot as the permit includes those exact requirements that petitioners claim are missing. And just like in the North Carolina case, MVP agrees it is bound by the terms of its application. It is bound to complete erosion and stormwater requirements here. So MVP agrees. The terms of the permit are clear. The permit incorporates the application. The application in turn requires MVP to comply with the standards and specifications and also with site-specific erosion sediment control and stormwater management plans.
Well, counsel,
But
tell
you
me.
can see why, I'm sorry.
No, go ahead, Judge Wynn.
You can see why they would have some degree of skepticism, even if they were not the same case or the same situation, the blatancy of in West Virginia, the earlier case, that it really comes down and kind of unusual is how much can we trust you to say what you say you say? When you come in here and say it orally as opposed to putting it on paper, and it's, you know, it just seems like they want to have this more concretely stated. I guess that's the end result of what's going on here. But you've made those statements, and I assume you heard previously what was in in the North Carolina case, and I take it the same representations are being made here on behalf of Virginia.
Absolutely. And I think no matter how concretely an applicant says they'll do something, there's always the chance of a violation. And then that's why the agency has enforcement authority. Opposing counsel brought up the $2.15 million civil penalty that incurred on Mainline. DEQ will go after MVP if they break the law, if they violate the terms of the permit. But what's at issue right now is that the terms of the permit clearly include erosion and stormwater management requirements. And so to the extent that the concern is mainline violations, DEQ provided a reasoned explanation for why it believes that Southgate will not violate water quality standards. And that reasoned explanation can be seen in DEQ's response to comments. That's docket number 23-9, pages 65 to 72 of the ECF watermark. And the most important point here is that DEQ found that no exceedances of Virginia water quality standards attributable to MVP mainline were documented during or after construction, and that's on page 70. And as Judge Thacker pointed out earlier, that's based on over 11,000 inspections, as well as studies by the U.S. Geological Survey and Virginia Commonwealth University. And the reason why you can have violations, but we can still be confident that Southgate will protect water quality standards is in part because violations of erosion and sediment control measures do not always equate to actual violations of water quality standards. The vast majority of mainline's violations were related to not meeting administrative requirements. You can see that on page 70 as well. So that was missing timelines, reporting requirement. It was a lot of administrative requirements. I believe only 13% of the violations included an actual sediment release. MVP learned from mainline and made improvements to erosion stormwater management techniques. MVP Southgate is a smaller diameter pipe that is installed through less challenging, much flatter terrain over less distance. And mainline was plagued by unusually high precipitation levels in 2018, and we do not expect to see those issues repeat. And then finally, the Southgate permit requires daily inspections, which MVP will have to reimburse the cost of. So DEQ clearly considered mainline's violations, but gave a reasoned explanation as to why mainline's violations do not mean that Southgate will violate water quality standards. And in the same DEQ response to comments, DEQ notes that construction of the MVP mainline has been the most regulated, inspected, and monitored linear utility construction project in Virginia recent history, and perhaps ever. That's on page 67. And then the third point that I wanted to make, for the geosyntech report, the only allegation is that that report used the wrong West Virginia impairment threshold, and that this then affected the characterization of one of the streams evaluated in that report. This argument has no effect on DEQ's determination that Southgate's permit will not violate water quality standards. First, the geosyntech report is described by DEQ in its response to comments as supplemental data reviewed by the agency. That's on page 62. And that's compared to the USGS and VCU studies, which DEQ referred to as critical studies. Second, DEQ did not rely on the impairment threshold in the report. Virginia has its own stream conditions index. DEQ reviewed that supplemental data from geosyntech as a comparison of pre and post construction conditions, not as an indicator of impairment or non-impairment. In its review of the relevant portion of the geosyntech report, DEQ found that 3 of the streams actually improved in quality, 4 had only a very minor decrease, and only 1, Teals Creek, had a notable decrease. DEQ examined that data point and noted that the report did not evaluate whether mainline was the cause of that decrease, And also, that data was taken within 6 months of construction, which is still within the time period when we expect to see stream health continue to improve. Further, Teals Creek is impaired by Virginia standards, but it has been impaired since 2002, long before Mainline began construction. And you can see that in DEQ's 2024 integrated report, a hyperlink to which is provided in DEQ's response to comments on page 62. And then a very important piece to note here as well, in its response to comments, DEQ notes that no area downstream of Mainline became impaired since construction of Mainline began. And that's in response to comments, page 62. And again, that goes with the point we were discussing about the violations. DEQ has found no significant impact to water quality standards attributable to Mainline. You can see that in DEQ's response on page 40 and on page 67. Again, this is based on more than 11,000 inspections, the critical USGS and VCU studies. DEQ has found that even Mainline, a much larger project over much rockier, more mountainous terrain, had no significant impacts to water quality standards. DEQ addressed these issues in its reasoned explanation, and because petitioners have not shown a strong likelihood to succeed on the merits, I respectfully request that this court deny the motion for stay. Thank you.
All right. Thank you, counsel. Mr. Tini? I'm sorry, Mr. Marwell.
Thank you, Your Honor. May it please the court, Jeremy Marwell here on behalf of Respondent Intervenors, including Mountain Valley Pipeline. I'd like to start and focus on the enforceable condition point, given the discussion between the court and the other counsel. We again agree with the Commonwealth about the interpretation of Condition A4, shall conduct authorized activities as described in the joint permit application that includes our standards and specifications and the enforceable erosion and sediment control plans. This is consistent with, it's not an unusual thing. This A4 condition is part of the Commonwealth's or the department's template 401 on its website. It makes sense. It's EPA guidance cited in our briefs explains why it would make sense to do this. The conditions that an agency needs to impose sort of depend on what somebody is proposing, and this way they set the baseline with what we're proposing. So to the extent that is our position, hopefully that is clear both in writing and for the court. On the adequacy of the agency's explanation, happy to take any questions. I guess I would just say the agency came at this every which way one can imagine, looking at a vast body of data that was gathered both by regulators and by Mountain Valley Pipeline. As I said, we took the mainline experience very seriously. We are looking not to repeat it, and we took a deep dive into what the actual science and data shows about the impacts of the mainline, and the agency engaged with that. If that is not a reasoned explanation, I'm not sure what would be. And we think the agency, there is no inherent inconsistency. The agency looked with open eyes at the compliance record, its own compliance record from construction in Virginia, and it explained why the specific kinds of issues that arose in the mainline both did not result in violations of water quality standards and were not going to disturb their judgment, their predictive judgment that we could conduct this much smaller, narrower diameter project over easier, less steep and easier terrain in a way consistent with the state's water quality standards. I would say what I said in the earlier argument with regard to the other three factors, which I know the court also needs to grapple with. The public interest we think is important because of the reasons this pipeline is being constructed, again, to serve two major utilities, to meet demonstrated need. I know the court has the hard job of balancing those sometimes imponderables.
Address the preemption point that the other made. Can a state agency, in your mind, avoid preemption laws by just incorporating them by reference?
Yes, so the Natural Gas Act, and I think this is all consistent with what this court said in West Virginia, the West Virginia DEP case. The Natural Gas Act explicitly saves from preemption the authorities of states under the Clean Water Act, the Clean Air Act, and the Coastal Zone Management Act. And so I think the law is clear that when the state is acting pursuant to its Clean Water Act authority, that is not preempted. I mean, to be honest, that's why we're here. If a municipality had a zoning law that said, we don't want a pipeline in our town, that is the kind of thing that we think would likely be preempted. You'll see cases on that. But here the state is acting pursuant to its Clean Water Act authority, and that's what I take the court to have said about preemption. And so the point is that the 401 certification is enforceable. And we think these obligations flow from condition A4 of the certification.
Thank you.
On the balancing of equities, there are several cases in our briefs, Sierra Club versus Army Corps, one from the Western District and one from Western District of Texas and one from the DDC, where then Judge Jackson, now Justice Jackson, grappled with how do you balance things like irreparable harm against need for a pipeline. Those are both pipeline cases. We thought that analysis was persuasive. To the extent that is useful or to the court instructive, we would refer you to that. If there are no further questions, we would urge the court to deny the motion for stay.
Thank you, Mr. Mauer. Thank you, counsel. Mr. Tini?
Thank you, Judge Gregory. A few points in rebuttal. First, on the question of the condition incorporation, Mr. Marwell relies on an EPA guidance that they cited in their brief. That guidance is from 2010, and it was expressly rescinded by the EPA in 2019. And since that time, the regulations have made clear that if something is necessary, made clear that the statute means what it says, that if something is necessary for compliance with water quality standards, it should appear as a condition in the permit rather than in the description of the project, which is really, again, all that is doing is describing which streams, where, and what crossing method, not what environmental compliance measures will be used. On the question of waiver, on the condition argument, counsel for the Commonwealth has cited the regulation. I'd also direct the court to the statute, the Virginia Administrative Code 10.1-1184.1. The Commonwealth, once again, takes the position that what we offered was new information, but it was directly responsive to statements made in the summary and response to comments. So it is squarely within the language of the statute and the regulation as permissible comments. On the question of compliance with water quality standards, I think we need to listen carefully to what the counsel for the Commonwealth is saying and what they wrote in their brief and what DEQ said. That they are saying, first of all, there were no significant effects on water quality standards. And that sounds a lot like what this court rejected in the West Virginia case, where West Virginia was insisting that there were no significant effects on water quality standards in that case. They described them as minor. They relied on language about significant adverse changes. But this court held that no water quality standards violations are permissible. And then also listen carefully to what they are saying. It's an admission that they're applying the wrong standard, because time and again they point to water quality standards, ignoring that the regulation requires them to assure compliance with all water quality requirements, which is not limited to just standards, but also includes those erosion and sediment control violations that the agency admits have occurred. Finally, on the question of whether or not the geosyntech issue was, well, first, it was a clear error. The agency was made aware that the impairment threshold under the metric that they were evaluating was far higher than what MVP had told them it was. They did not respond to that. They did not engage with or grapple with that contrary evidence. They did not explain that, well, this is a Virginia standard This is a Virginia stream, not West Virginia. None of that is in their explanation. They just acknowledged the comment was made and went on their merry way. And you cannot decipher what are the independent grounds on which Virginia has made this conclusion. They keep citing 9 different studies and suggest that somehow we have to run the gauntlet of showing that each and every one of them was defective. That inverts the standard on its head. As the Supreme Court held...
So now they've said too much in their explanation. I mean, in the case before, you were arguing that they didn't say enough, and so that wasn't a sufficiently rational explanation. And now it sounds like you're saying they've provided too much information so we can't grapple with it. That you can't grapple with it.
I don't think that's exactly what we're saying. What we're saying is, if the agency truly believed, for example, that the USGS data was independently sufficient, it could have and should have said that. And that's what the Supreme Court requires, and in the case that Mountain Valley cited, Food and Drug Administration versus wages and white line investments, that's at 604 U.S. At 590 to 91. There they explain that although a remand isn't necessary every time an agency makes a mistake, it is, you can only avoid it if it's absolutely clear that they would have, that it had no bearing on the decision they made. I see that I'm out of time. I thank the court for having these special arguments remotely and respectfully request that the court grant the motion for stay pending review.
All right. Thank you, counsel. Counsel, all. It's, again, we can't come down and shake your hands, but know that we appreciate your arguments here today, and thank you very much. With that, I ask that you would adjourn the court, I suppose, of sine die.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.